This evening we have Patrick Waller and Chelsea Loughran, and they're going to be talking about some Supreme Court decisions and how they're going to impact us. So, which of you would like to start and tell us what you're going to talk about?
Well, I could start. This is Patrick Waller. Thanks, Peter. So we're going to talk today about some recent decisions at the Supreme Court in cases that involve diagnostics and molecular diagnostic tests, and some of the impact that that's had on the industry, and also some of the impact on public interest. And there's a case that has been essentially going through the court, starting with the district court several years ago, through the appeals court to the Supreme Court this summer. It's referred to as the Myriad case, that essentially relates to genes that are useful for diagnosing breast cancer. And this has generated a lot of public interest, partly because individuals are interested in what's happening to their genes. It's generated some interest through Angelina Jolie, who's gone through some of the diagnostic tests involving these genes. And it also has a significant impact on the biotechnology industry, particularly in the diagnostic space. And essentially at issue are the patentability of genes, whether or not genes themselves can be patented and can be subject to patent protection. And just to maybe step back a bit, and maybe I'll let Chelsea talk a little bit about what's required for patentability, and then we can get into some details about genes themselves and what's interesting about genes and why this has such a big impact on the industry.
I mean, just for starters, for me, and I'm a lawyer and know very little about this, I didn't know you could patent genes. I thought genes were a naturally occurring part of your body. So,
just not your genes, Peter, please.
No, my genes are very special, but somebody want to tell me, you know, how I'm wrong?
Right, so that's a good question, and that is actually the question, a slight variation of that the Supreme Court recently addressed. Now, when you think about what you can get a patent on, courts, you know, for a long time have been grappling with what you actually can get a patent on, and have basically carved out certain things that you can certainly not get a patent on. Things like laws of nature. You can't get a patent on something like gravity. Things that naturally occur in nature. And so that goes to your point, which is, well, my genes naturally occur in my body. Those are a product of nature. Well, the gray line arose when companies like Myriad started isolating genes from their natural environment. Now, you can isolate the gene, but what is the gene? The opponents of Myriad's kind of genetic patenting processes said that was the gene is basically just information. And so when you're isolating a gene, you're really just isolating information that exists in nature. And so when the Supreme Court took up this issue this summer, they addressed a very specific question, which is, can you get a patent to an isolated gene? Basically pulling that information out of a cell and using it to do some type of diagnostic test. And that was, you know, the Supreme Court was very clear that was the only question that they were going to grapple with, which was whether pulling the information out, pulling the gene out of its cell and replicating it, using it for diagnostic testing, whether you could get a patent on that.
So we're talking about a single gene.
Correct.
Being pulled out of its genome sequence, and whether that is information or a